Good morning, Your Honors. May it please the Court, my name is Ben Zimmermann. I represent the plaintiffs, appellants Edwin DeJesus and Maria Cartagena. In 1984, Birch, a division of Deem, became Birch, a division of Park. And the question here is whether, in that corporate transaction, there are sufficient facts presented below to hold Park liable to Edwin DeJesus for the loss of his limb in a Birch machine. The doctrine at issue in this appeal is the de facto merger doctrine under Massachusetts law. And as applied in Massachusetts, it is supposed to look behind a corporate transaction, usually a purported asset sale, to see if it inequitably attempts to cut out creditors and tort claimants and people who were hurt potentially, either monetarily or otherwise, by the predecessor corporation. Under Massachusetts law, the de facto merger doctrine is supposed to be a fact-intensive, case-by-case, equitable doctrine analyzing four non-dispositive, non-exclusive factors. And the policy behind it is the protection of creditors and tort victims. And that's what the Supreme Judicial Court has said in several recent cases. And that's the law that Massachusetts courts follow. The district court below and this court have clear precedent in the form of the Cargill case in 1997 and the Milliken case in 2008 from the Supreme Judicial Court that says on their face that no single factor in the de facto merger analysis is necessary or sufficient or dispositive. And every Massachusetts trial court that has addressed the precise issue raised in this case has held that continuity of ownership is not dispositive in the analysis and has denied summary judgment on that basis. Despite this Massachusetts law that is clear on its face, the district court found that 3 of the 4 de facto merger factors were well developed and, quote, satisfied, but wrote an opinion that said that under Massachusetts law, commonality of ownership in a corporate transaction is required to find a de facto merger. And the question before us is, was that error? And the answer, under any fair reading of Cargill and Milliken and the Massachusetts law on the subject, is yes, it was error. It's kind of an interesting tension because when we look at the SJC's plain statement of the law in Cargill and Milliken, and then we look to the Superior Court decisions that have followed that precedent, you have a decision from Judge Agnes, who's now on the appeals court in the Dominguez case in 2009. You have an opinion from Judge Gantz, who's now on the SJC in the mass printing case, that's in 2000. And you have a decision by Judge Fabricant, who's still in the Superior Court, but a well-known jurist in 2010, who has said, we've looked at the facts of these particular cases. All 3 other factors are satisfied, but not commonality of ownership. And we're going to deny summary judgment to the successor corporation because of that fact. And we're not going to find commonality of ownership to be dispositive.
May I ask you a kind of complimentary question? I take it that you accept the proposition that what seems to be called mere continuity of enterprise, standing alone is not enough.
In Massachusetts, that's correct.
Okay. My next question is, or I'm going to make an assumption, and ultimately I want you to comment on the assumption. The assumption is that if you do have a continuity of enterprise, you're probably going to have at least 2 of the other 4 considerations along with it. Maybe not in every case, but in most. The prior corporation is probably going to disappear as a separate legal entity. And there probably is going to be an assumption by the new corporation, the new owner of at least call them the working liabilities of the prior corporation necessary to just keep on running from day to day. So that if you have continuity of enterprise, which isn't enough, you'll probably have these 2 other factors. And if that is the case, why will there ever be a de facto merger unless there is also some continuity of ownership?
The answer to that question is this, and it is a point that Park has raised in their papers, and that was addressed by the district court, which is, well, geez, if you deny summary judgment here, and if you send this to a fact finder, because there's no continuity of ownership, what you're really doing is you're applying the continuity of enterprise doctrine, and Massachusetts is not continuity of enterprise jurisdiction. Right. That is not the case. That's not logically the case. Continuity of enterprise wouldn't even consider whether commonality of ownership, whether there was commonality of ownership. It doesn't consider that factor.
No, I think we all understand that, and we also understand, as you do, that continuity of enterprise will never be sufficient under Massachusetts law. Well, so if enterprise is never going to be sufficient, and enterprise normally carries with it disappearance, assumption of operating liabilities, then those three together presumably are not going to be enough, because they'll always be together. And the only thing that is going to take you across the goal line, the only remaining possibility, is continuity of ownership. And that's the argument that I'm asking you to respond to.
I think that continuity of enterprise and continuity and de facto merger and what's known as mere continuation in Massachusetts are subsets of, obviously they're different doctrines related to successor liability, but just because you can reach the same conclusion in a de facto and merger analysis in Massachusetts as you do in a continuity of enterprise analysis, in other words, even though the result is maybe the same under continuity of enterprise and de facto merger if you accept our argument, that doesn't mean the doctrines are the same. That doesn't mean you're applying a continuity of enterprise doctrine. It means that you're doing exactly what the Supreme Judicial Court says you're supposed to do, which is to look at every single transaction on a case-by-case analysis and say, yes, in many cases, you may fail because you don't have commonality of ownership.
If that's true, then the only case in which there will not be a finding of de facto merger, if there is a finding of continuity of enterprise, is the case in which the person who is stating the facts is so dumb or ignorant that he doesn't also add, and by the way, the first corporation disappeared, the first owner disappeared, and the operating liabilities were assumed. It's almost as though the difference between a finding that commonality of enterprise is not enough and a set of findings that would be enough boils down to the inadvertence of the person who is sort of stating his reasoning.
Yeah, I don't think that's correct, Your Honor, frankly, because there are cases, reported cases, in Massachusetts as well, that the predecessor corporation continues on, either in another business or with another product line, and so you're not going to always have those three factors.
So you're saying you may have the three factors in a great many cases, but you don't have them in all of the cases.
You don't have them in all.
That's all you need to win.
In Massachusetts, that's correct. Okay. And the reason is because it's not just a matter of do you have A, B, C, or D. It's a matter of looking behind the corporate transaction and saying, what was really going on here? What's happening here? Because in order to follow the district court's, in order to uphold the district court's opinion, what you're going to have to say is that when the SJC said no factor is dispositive, it really meant that one was. And what Judge Young did below is he went with the opinions of Judge Saylor in the district court and Judge Gertner in an opinion in National Gypsum, which was decided before Cargill. And he said, well, I'm going to follow them instead of what the state courts in Massachusetts are doing. And if we are really going to say that the SJC has written several times that no factor is dispositive, but they really didn't mean it, then it is our position that that question ought to be asked to the SJC because they've said it repeatedly, and that's what the Massachusetts courts are doing.
Let me ask you one last question, then I'll let you go.
Okay, that's fine.
Is there any basis upon which we could conclude here, in this record or in the literature, about let's say, the percentage of instances in which you would have continuity of enterprise, but not have either continuation of the prior owner or assumption of operating liabilities?
In this record, I cannot see that anywhere to be found. or frankly in the reported cases. And one of the reasons for that is the reason that the SJC, and which actually Judge Young in Acushnet said, is the whole reason for this de facto merger doctrine is because there are infinite permutations of corporate transactions that can be used to avoid creditors either fairly or unfairly. And what we're going to do is we're not going to look at it and say, okay, we have an asset purchase agreement. It's an asset purchase agreement. There's no commonality, therefore no liability passes. Because once you do that, you've created two situations. One is you've made it very easy to get around a successor liability. And the second thing you've done is you've turned Massachusetts not into a de facto merger or a continuation of enterprise jurisdiction. You've turned it into an actual merger jurisdiction. In other words, you have to prove that an actual merger occurred to prove a de facto merger. And that's not the law.
Isn't the real nub of this that there has to be some form, I think the lower court said the court considers where the shareholders used a disguised mechanism to transfer the legal ownership of the corporation, but ultimately retain the control. But we really don't have that here, do we? I mean, isn't that sort of the substance and the heart of the de facto merger doctrine? And what do you have to point to that suggests that this was the Birch Corporation and its owners and controllers trying to keep control and get out from under the bad stuff?
Okay. I think that the premise, in fairness, I think that the premise of the question is faulty, because that is a position that's been taken by some courts that a desire to continue to control the corporation is necessary for finding a de facto merger. That is not what Massachusetts law says. And you've asked for evidence of that. Look at the Cargill case.
No, but evidence in your case.
Oh, well, there is no commonality of ownership, and there is no...
Or is there anything that would suggest that the whole going into bankruptcy and then being purchased by Park, is there anything to suggest that that was sort of a ruse, that was all about keeping the shareholders that have the first company in control at the end?
Well, I think the question is only looking at the shareholder side of things as opposed to the creditor and tort victim side of things, which is what the de facto merger analysis is doing, is not just looking at, well, do shareholders keep control or not? It's what's being done to these claims. Is it unfairly treating creditors? And if you look, if Your Honor would indulge me, if you look at the Cargill case, there's no intent to control there. In Cargill, there was a cash sale of assets, and the shareholder of the predecessor used that cash to buy 12.5% of the share of the successor.
Right. I think it has that element of I want to keep control of this company.
At 12.5%?
Maybe it was just one shareholder doing it, but they at least had one shareholder.
Well, what the court said in Cargill is right in Cargill it says no factor is dispositive. And when analyzing the one factor of commonality of ownership, they said, well, 12.5%, it's some control or it's some evidence of control, but it doesn't say that you have to have that to have a de facto merger. It just doesn't say that. And in fact, it says, one could argue it says the argument. It says the opposite. And if you look at this case, it kind of illustrates why you can't have one factor dispositive. Because what you have is a company that is talking about selling their stock to Park Corporation for a certain price. And they say, well, that price seems a little high. Why don't we get rid of all the people who've been hurt by the machines and all the claims going forward? And the way we'll do that is we'll sign an asset purchase agreement that requires you to file for bankruptcy. There's no prior bankruptcy planned. We're going to put right in there that we're going to require you to file for bankruptcy, and then we're going to come out on the other end of it, and we're never going to have to pay plaintiffs again. And that is the kind of transaction that a Massachusetts court would look at and say, hey, I think this is for the fact finder here, because that doesn't sound right. And that's what the equitable doctrine is all about. And for 29 years, we're 29 years after this transaction, and Park is litigating in every jurisdiction and their insurer whether, whether successor liability applies under that jurisdiction's law of successor liability. And 3 New York courts denied them summary judgment on this issue. One court found the asset purchase agreement under the continuity of enterprise analysis, I grant you, in Dillman in Pennsylvania, found that the purchase agreement itself to be smoking gun evidence of a collusive bankruptcy filing to avoid creditors. And on those facts, in Massachusetts, the way the Massachusetts courts are applying this law, there is no Massachusetts court, if you went before Judge Gantz, Judge Agnes, or Judge Fabricant, who's going to say, yeah, summary judgment for Park on those facts. That's just not Massachusetts law. Thank you.
By the way, Mr. Zimmerman, I took a lot of your time with my questions, but your answers were very helpful to me.
Thank you.
Good morning, Your Honors. If it pleases the Court, my name is Stan Yours. I represent Defendant Appellee Park Corporation. Judge Young committed no error here. Judge Thorson, if I could be so bold as to answer the question you asked my colleague, there's absolutely nothing in the record here that would indicate any type of fraud or conspiracy, and none has been pled. Plaintiff is not relying on any type of fraud exception here. What we do have in the record, however, is a clear asset purchase by Park of certain machinery of Birch. It comes clearly under the general corporate rule that asset sales of this type do not impose liability for preceding acts on the purchasing corporation. Much has been said here of the continuity of shareholders, of ownership. And my colleague mentioned that, well, there are no superior court rulings with regard to this in Park's favor. I suggest a very interesting comparison is to look at the Scott case, which we cite in our briefs. In the Superior Court, and this is after Cargill, the case they cite often, after Cargill, the Superior Court says, in determining whether a de facto merger has occurred, courts pay particular attention to the continuation of management, officers, directors, and shareholders. Central to a de facto merger is a finding that the shareholders continued into the buyer corporation. That's a Superior Court. Went up on appeal. The Appellate Court, same thing. In determining whether a de facto merger has occurred, courts pay particular attention to the continuation of management, officers, directors, and shareholders. The key element of a continuation is a common identity of the officers, directors, and shareholders. It's the Appellate Court. That went up to the Supreme Judicial Court as well. And there, while it was reversed on other grounds, not involving successor corporations, that court said, likewise, for the reasons stated by the motions judge and those expressed by the appeals court in Part 3, which is the part I just read to you, the order of the Superior Court judge allowing defendant Boston Gas Company's motion for summary judgment was correct. Even after Cargill, it was not a watershed decision, I suggest to the court. Even after Cargill, courts continually look at all four of the criteria for a de facto merger. And to my knowledge, no Massachusetts appellate court, either the Court of Appeals or the Supreme Judicial Court, has found a de facto merger without continuity of shareholders. And I would suggest to the court that, Justice Souter, your question was on point, because if you do not have continuity of shareholders, you're into the disfavored, not adopted by Massachusetts theory of continuation of enterprise. Massachusetts courts have not accepted that, but if you wrench out continuity of ownership, then that's exactly what you have. And we don't have that here. And in fact, that is why when you look at the Supreme Judicial Court opinions, they take pains to go over all of the factors. In fact, to my knowledge, the Supreme Court has not found a de facto merger without looking at all of the factors and finding all of the factors. And in Cargill, for instance, 12.5%, well, yes, it was 12.5%, but he was a sole shareholder in a close corporation. Clearly, there was continuity of ownership in that case. The district courts in Massachusetts and this court have numerous times indicated the same thing, that central to the de facto merger doctrine is the idea of continuity of ownership. Now, are there a couple of superior court cases that apparently dispense with that? There may seem to be, although looking at the record it's difficult to tell exactly. But I would suggest to you that you must look at the record of the appellate courts in Massachusetts. And this court itself, in the Dayton case, said that appellant directs our attention to memorandum and order of Massachusetts Superior Court denying successor corporation's motion for summary judgment on the basis of the product line theory. This is an older one where people are still arguing about the product line. But this court said such an order does not rise to the level of persuasive, let alone binding presidential authority, and we refuse to hinge our interpretation of existing Massachusetts law on it. Similarly here, I suggest this court hinge its interpretation of Massachusetts law on what the Massachusetts Supreme Judicial Court said and on what the courts of appeal have said. And Judge Young certainly is someone to know about it. His Acushnet case has been cited numerous times by both the Court of Appeals and the Supreme Judicial Court.
So about Acushnet, one of the ways I've been thinking about this case is that, perhaps the point that Judge Young was making is that continuity or identity of shareholders is a sine qua non, but perhaps the point really is that it was a tipping point. That if you look at the enterprise continuity, continuation of enterprise factor, aren't there a number of subparts to that? And those are? What are they? Under Acushnet in particular.
Under Acushnet, you have the destruction or the elimination of the prior company, the continuation of the business, and I apologize, Your Honor, there's one more.
So I thought it included things like continuity of management. Where's the location of the operations?
Those are facts to look at, certainly.
And how do those play in this case?
Well, in this case, frankly, Your Honor, I believe Judge Young would have been correct had he decided this on the basis that other of these factors were not present. When Park purchased the assets of Birch, again, it was only an asset purchase. They eliminated several of the lines. They took many of the operations that had been in Cambridge City, Indiana, transferred them to Pittsburgh. Inventory, sales practices.
What about personnel and
management? The record is a little unclear. There were about 50 to 100 employees of Birch. A handful of those were retained by Park. Three primary engineers with Birch. Two of them were retained by Park in different job titles, different descriptions. One was not.
So if the record would support that as to that particular prong, the continuity of enterprise prong, that it's more in equipoise or it's not so one-sided, can't you then think of the shareholders as a tipping point as opposed to a sine qua non?
I could think of them as tipping point. In fact, well,
is there anything in Massachusetts law that would suggest that's an inappropriate way to look at it?
No. In fact, certainly the district courts have spoken about typically the continuity of shareholders is, I'm not sure if they use the word tipping point, but they do mention that as the most important criteria. Judge Howard, your own Divine case back in, I believe, 2002, conceivably under Virginia law, you used, I'm not sure you used tipping point, but it was something like that, that even if some of these other criteria are present, if you don't have the continuity of ownership, whether you want to call it a sine qua non or a tipping point, if you don't have it, you just don't have a de facto merger. Unless there are other questions, that's all I have, Your Honors.
Okay, thank you both.